Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather, and we're here to talk about the 10-day waiting period. Again, this time, Justice Thomas's opinion. Well, it's really a statement, if you want to know the technical term. He's dissenting from the denial of certiorari. This was when Silvester versus Becerra, because Kamala Harris moved on to the Senate, in case you didn't know that. The new defendant is still the Attorney General of California, this time Becerra. He's dissenting from the denial of the Supreme Court taking this case. Now, we've done several episodes now, I think 3 actually, on Judge Ishii's opinion as we're going through it on California's 10-day waiting period. You might be wondering, why in the heck are you spending this much time on this on the Republican Professor podcast? Surely, please don't call me Shirley. There are other things worth talking about in the world. And yes, there are, but you could say that about any topic we cover for any amount of time. There are a lot of things to cover. And we're focusing on this because it's an example of what's important, and it's part of the history of the Supreme Court litigation on this issue. The constitutional law that's developed is a part and parcel of American politics. And a lot of folks just don't have the attention span to put it all together, and for good reason. We're just finite creatures. We're just doing the best we can. So I'm going to link this in the description below, but this is Justice Thomas talking in 2018 when the Supreme Court denied hearing this once it was overturned. Ishii's opinion was overturned by the Ninth Circuit. And this provides background because you remember Justice Thomas was the writer of the majority opinion in New York Rifle and Pistol Association versus Bruen in late June of 2022. Remember that? It was Justice Thomas that wrote that, which means that the Chief Justice allowed him to write that, because the Chief Justice gets to decide who's writing that opinion if it's not him. And as long as Chief Justice is on that side, and he was. So Justice Thomas was writing these dissents from the denial of cert over and over again. And what he was writing for years eventually made its way into that Bruen decision for the majority of the court, which is now the law of the land. Okay. Justice Thomas dissenting from the denial of certiorari, February 20th, 2018, in Jeff Silvester versus Becerra. That used to be Harris when Kamala Harris was Attorney General. This is Justice Thomas. The Second Amendment protects the right of the people to keep and bear arms, and the 14th Amendment requires the states to respect that right. Because the right to keep and bear arms is enumerated in the Constitution, courts cannot subject laws that burden it to mere rational basis review. But the decision below did just that. That's talking about the Ninth Circuit trashing Ishii's work on this. Ishii's work we've been going through for the last 3 episodes. Purporting to apply intermediate scrutiny, the Court of Appeals for the Ninth Circuit upheld California's 10-day waiting period for firearms based solely on its own quote unquote common sense. That's in Silvester versus Harris. That's in volume 843, third edition of the Federal Reporter. Sorry. Yes, volume 843, starting at page 816 and at 828. Okay. It did so without requiring California to submit relevant evidence, without addressing petitioners' arguments to the contrary, and without acknowledging the district court's factual findings. I'm going to read that again. Justice Thomas. The Ninth Circuit overturned Ishii's opinion that we've been going through for the last 3 days. We're in the middle of it. We haven't finished. I'm doing a little excursus here. It did so without requiring California to submit relevant evidence. Let's just stop right there. What's your reaction to that? Is that okay? It did so without requiring California to submit relevant evidence, without addressing petitioners' arguments to the contrary, and without acknowledging the district court's factual findings. What Justice Thomas just did there, and remember, at the time, the Supreme Court didn't take this. But over the years, the Chief Justice was watching what Thomas was saying. And then once New York Rifle and Pistol Association versus Bruen happened, the Chief Justice said, "You're writing the opinion." The Supreme Court, the voice of the Supreme Court in Bruen is saying 4 years before that the Ninth Circuit, which covers multiple states and a huge land area, including Alaska, Hawaii, California, two of the biggest size-wise states are Alaska and California. It's an enormous part of the United States in terms of geography. And that appeals court overturned a careful analysis by a Democrat judge at the trial level on the 10-day waiting period without addressing the arguments, without requiring the defendant, California, to submit relevant evidence, and without acknowledging the district court's factual findings. And it was a Democrat judge. It was a Clinton appointment. This deferential analysis, deferential toward the state, was indistinguishable from rational basis review, Thomas says. And it is symptomatic of the lower court's general failure to afford the Second Amendment the respect due an enumerated constitutional right. If a lower court treated another right so cavalierly, I have little doubt this court would intervene. But as evidenced by our continued inaction in this area, the Second Amendment is a disfavored right in this court. End of page 1. I'm going to link this below. We're on page 2. Because I do not believe we should be in the business of choosing which constitutional rights are, quote, really worth insisting upon, unquote, quoting Heller, 634, I would have granted certiorari in this case. When the average person wants to buy a firearm, okay, hold on one second. Sorry, I just want to point out a timeline here. This is in 2018 in February. Who was on the Supreme Court at that time? Requires 4 people to hear a case. Well, one Trump appointment was on the Supreme Court, the replacement of Antonin Scalia. That would be Justice Gorsuch. Kavanaugh wasn't on there yet. Remember? Kavanaugh's fight for confirmation came 6 months later, in August and September of 2018. Okay. And then, of course, Ruth Bader Ginsburg was still on there, and she was not replaced yet by Amy Coney Barrett. So 2 of the 3 Trump judges that turned justices were not on the Supreme Court when Thomas wrote this. Just keep that in mind in terms of the political dynamics here. And remember, Supreme Court justices are confirmed by the United States Senate. So it's not just presidential politics we're talking about. We're talking about state politics when it comes to Congress, the upper house of Congress, the Senate. I'm going back to Justice Thomas. When the average person wants to buy a firearm in California, he must wait 10 days before the seller can give it to him. This 10-day waiting period applies to all types of firearms, but it has exceptions for certain purchasers, including peace officers and special permit holders. California's waiting period is the second longest in the country. Besides California, only 8 states and the District of Columbia have any kind of waiting period. 4 of those jurisdictions have waiting periods for all firearms. The other 5 have waiting periods for only certain types of firearms. Previous versions of California's waiting period, likewise, were limited to handguns. California enacted its current waiting period for 2 reasons. First, the waiting period gives state authorities time to run a background check. In addition to the background check required by federal law, California requires its own background check, searching at least 6 databases to confirm a purchaser's identity, gun ownership, legal history, and mental health. One of those databases, the Automated Firearms System, AFS, collects reports to help determine who possesses a given gun at a given time. Second, California's waiting period creates a, quote, cooling off, unquote, period. The 10-day wait window gives individuals who might use a firearm to harm themselves or others an opportunity to calm down. Petitioners Jeff Silvester and Brandon Combs are lawful gun owners who live in California. They, along with 2 nonprofits, filed a lawsuit challenging the constitutionality of California's waiting period under the Second Amendment. Specifically, petitioners allege that the waiting period is unconstitutional as applied to, quote, subsequent purchasers, unquote, individuals who already own a firearm according to California's AFS database, and individuals who have a valid concealed carry license. After a 3-day bench trial, the district court entered judgment for petitioners. That is for the Second Amendment, for the gun owners and their interest at protecting their constitutional right to be able to buy a firearm without waiting for it as long as they pass a background check. Okay. Going back to Thomas here. Applying intermediate scrutiny, the district court concluded that California's waiting period was not reasonably tailored to promote an important government interest. Now, one quick note here. Bruen did away with these tiers of scrutiny. So this is a historical note. You should pay attention to the history here. The reference to intermediate scrutiny. Regarding background checks, Thomas continues, the district court found that 20% of background checks are auto-approved and take less than 2 hours to complete. That would mean if you show up at the gun store in the morning, you could go get a cup of coffee, maybe a salad, and come back in the afternoon, and the same day you'd have your firearm. You could walk and then come back. The other 80% take longer. So 20%, we covered this. 20% of background checks are auto-approved. That's in the record, it's fact. Takes less than 2 hours. Actually, it said it took about an hour at least. Not more than an hour. The other 80% take longer, but petitioners did not challenge the background checks or the time it takes to complete them. That left the cooling off period. After reviewing California's studies on the relationship between waiting periods and gun casualties, the district court found them inconclusive. The district court also noted that studies seem to assume that the individual does not already possess a firearm. California submitted no evidence about subsequent purchasers, which was significant because a waiting period will not deter an individual from committing impulsive acts of violence with a separate firearm that is already in his or her possession. Even if some cooling off period is necessary, California made no attempt to defend a 10-day waiting period, and the background check process will naturally create a waiting period of at least 1 day for 80% of purchasers. The district court also found that the individuals who meet California's requirements for concealed carry license are uniquely unlikely to engage in impulsive acts of violence. California argued that a waiting period could still work for subsequent purchasers in some circumstances, but the district court rejected this argument as overly speculative. While a subsequent purchaser's firearm could be lost, stolen, or broken, California submitted no evidence to quantify how often this occurs. And state authorities could always check the AFS database to determine whether a subsequent purchaser still had a firearm, a reliable method that law enforcement officers use in the field. Further, California did not prove that waiting periods deter subsequent purchasers who want to buy a larger capacity gun. California's expert identified only one anecdotal example of a subsequent purchaser who had committed an act of gun violence, and the expert conceded that the waiting period would not have deterred that individual. I'm at the bottom of page 4. Again, this is going to be linked in the description, so you can check it out. Thomas again. The Court of Appeals for the Ninth Circuit reversed. The Ninth Circuit spent most of its opinion summarizing the background of this litigation. Summarizing circuit precedent on the Second Amendment and this court's decision in Heller, including the dissent. The Ninth Circuit then concluded that the test for intermediate scrutiny from First Amendment cases applies to California's waiting period, stressing that this test is not a strict one. The Ninth Circuit held that California's law prevents gun violence by creating a cooling off period. They really like that cooling off period thing. It's helpful to zero in on that then. Although California's studies did not isolate the effect of waiting periods on subsequent purchasers, those studies confirm the common sense understanding that cooling off, this is according to the Ninth Circuit, that cooling off periods deter violence and self-harm, an understanding that is no less true for subsequent purchasers. The assumption that subsequent purchasers would just use the gun they already own was, quote, not warranted, unquote, the Ninth Circuit concluded. While it assumed that the AFS database would accurately report whether a subsequent purchaser still owns a gun, the Ninth Circuit noted that a subsequent purchaser, quote, may want to purchase a larger capacity weapon that will do more damage when fired into a crowd, unquote. That possibility was enough for the Ninth Circuit to uphold California's waiting period, since intermediate scrutiny requires, quote, only that the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation, unquote. Wow. How are you doing? I need to get a drink of water here. Jeez. All right, back. I'm on page 5 at the bottom. The Second Amendment guarantees a personal right to keep and bear arms for lawful purposes, quoting MacDonald at 780, plurality. This court has not definitively resolved the standard for evaluating Second Amendment claims. Heller did not need to resolve it because the law there failed any of the standards of scrutiny that we have applied to enumerated constitutional rights. After Heller, the courts of appeals generally evaluate Second Amendment claims under intermediate scrutiny. Several jurists disagree with this approach, suggesting that courts should instead ask whether the challenged law complies with the text, history, and tradition of the Second Amendment. Although Heller did not definitively resolve the standard for evaluating Second Amendment claims, it rejected two proposed standards. The court first rejected a freestanding interest balancing approach, which would have weighed a law's burden on Second Amendment rights against the governmental interests it promotes. Quote, the very enumeration of the Second Amendment right, Heller explained, unquote, Heller explained, eliminates courts' power to, quote, decide on a case-by-case basis whether the right is really worth insisting upon, unquote. That quote right there, put that on a coffee mug, put that on a calendar. That is June in Natural Right magazine, centerfold. The court also rejected rational basis scrutiny. Heller found it obvious that rational basis review could not be used to evaluate the extent to which a legislature may regulate a specific enumerated right. Otherwise, the Second Amendment would be redundant with the separate constitutional prohibitions on irrational laws and would have no effect. I'm on page 7. 7 at the top. Rational basis review is meaningfully different from other standards for evaluating constitutional rights, including the intermediate scrutiny standard that the Ninth Circuit invoked here. While rational basis review allows the government to justify a law with, quote, rational speculation unsupported by evidence or empirical data, unquote, intermediate scrutiny requires the government to, quote, demonstrate that the harms it recites are real, unquote, beyond, quote, mere speculation or conjecture, unquote. And while rational basis review requires only that a law be rational at a class-based level, intermediate scrutiny requires a reasonable fit between the law's ends and means. Let me interject here briefly. I just want to point out that he is referring to precedent a lot in here, and there's some footnotes. I'm skipping over the cases he's citing just for the ease of exposition. And of course, it's very helpful to have this, know where things are on this topic. In case your kid wants to do a paper on the 10-day waiting period, have them listen to this podcast and refer to those things. He or she will be good to go. Okay, Justice Thomas again, page 7. The Ninth Circuit claimed to be applying intermediate scrutiny, but its analysis did not resemble anything approaching that standard. Let me say something here. What Thomas is pointing out is the politics of Democrat judging when it comes to the constitutional rights that affect all Americans. And so what they'll do is they can't say it's rational basis what they're doing because the government always wins on rational basis. They can't say it's rational basis because it's an enumerated constitutional right, and they wouldn't be able to get away with that. I mean, so they have to have some cover, and the cover is they say we're giving heightened scrutiny. Okay, and so they have that discretion to uphold the law that they like, and also still say that they're applying heightened scrutiny. But that's just a cover. And what Thomas is saying is, but the requirement for heightened scrutiny, that's not what you're doing here. You're calling it heightened scrutiny, but you're actually just applying rational basis. And you're assuming that Americans, A, are not going to pay attention. They're not going to read this. And so they'll just let the government encroach more and more on the rights because Americans are distracted. They don't have attention span. Even some of the listeners to this podcast have kind of a consumer mentality, like what's in it for me kind of a thing, and it's like, well, this like deep understanding, if that's not important to you, I don't know what else to say. So I'm just giving this stuff away. I mean, it's not like I'm charging for this. If you don't have an interest in that, then what kind of citizen are you? And I'm just adding to the record here. I'm not trying to convolute the record. I'm just clarifying it. I think clarity is very important for the younger generation. And I'm even concerned about the older generation that never saw this before. In fact, I was just in a gun shop recently. I was in Bass Pro Shops in Irvine, and I was talking to one of the employees there, and he was an older guy, and I said, I see you're working here at Bass Pro. How do you like it? And he told me that he started when Gavin Newsom told him that he couldn't work in 2020, he started having a shift in orientation. And he said that he went out and stayed with his brother in a different state for a while, and they went shooting. I think it was like Utah or something. It was a red state. And he became a quote unquote gun guy. And he's older than I am. So I'm not just doing this for the younger generation. I'm doing it for older people too that are like, they're like, what's going on? The people I trusted, they just like the government so much, no matter what the government does. And uh, that doesn't fit with a constitutional way of looking at things. Because the Constitution limits the government. It doesn't empower the government to do whatever the hell it wants. This is like a basic point here about constitutional law. We do have a constitution. The Ninth Circuit claims to be applying intermediate scrutiny, but its analysis did not resemble anything approaching that standard, Thomas says on page 7. It allowed California to prove a governmental interest with speculation instead of evidence. It did not meaningfully assess whether the 10-day waiting period is reasonably tailored to California's purported interest, and it did not defer to the factual findings that the district court made after trial. The Ninth Circuit would not have done this for any other constitutional right, and it could not have done this unless it was applying rational basis review. Let me compare this with the marriage definition case that came down in 2010, Perry versus Schwarzenegger, the district court in San Francisco. I did a major paper on that when I was in graduate school. I presented it in front of a scholarly audience in a scholarly setting, actually a couple different times. I got some pushback because I criticized the opinion. That opinion, Perry versus Schwarzenegger, 2010, overturned Prop 8, which defined marriage at the state of California Constitution as what the dictionary said, which is a union between a man and a woman by which they become husband and wife. It defended that view. And the actual wording was very short, but it basically asserted that the dictionary was correct, and we will continue to use the dictionary. Well, in Perry versus Schwarzenegger in 2010, that was overturned. And the Ninth Circuit upheld that decision. If the Ninth Circuit had used the reasoning applied here that Justice Thomas is pointing out that they use for the Second Amendment, the Ninth Circuit would have overturned the district court. And California would have had the definition of marriage as a man and a woman in the Constitution, at least up until 2015, when Obergefell came down. So there's not a consistency. Now, here's a difference between arms and the definition of marriage. Arms are an enumerated right in the Constitution. Marriage is not enumerated. What do I mean by enumerated? I mean, there's no mention of the word marriage in the Constitution. So it's not that you don't have a right to get married. It's just really, we're not really talking about the right to get married. We're talking about what marriage means, the word means. So it's a little bit misleading when people talk about the right to get married as if the definition changing is not an issue. So you got to keep your eye on the ball there, rhetorically. I want to say that I did a whole series last summer on the definition of marriage. I think it's 4 videos on this, and you may not like them, but they are substantive. You might not have the attention span for it, which, I mean, you know, I get it. I go to the library all the time and I look around and I say, I don't have the attention span for all this. Doesn't mean the library is irrelevant. Doesn't mean that it's bad or I should turn in my library card. So don't unsubscribe just because you don't have the attention span. I mean, you might later, or your kid might, or your cousin, or whoever's working on a paper. But yeah, there's definitely they don't like the Second Amendment, and that's it. That's it. I mean, it's like when the KKK just doesn't like black people. You can't reason with them. What are you going to how maybe over time you can. I mean, I guess I know that there is an example of a guy. I don't know the names involved, but there was a black guy that befriended like a KKK, like a contemporary so-called KKK guy. And so we're not talking about like the historical KKK, which was, you know, Civil War inspired. But apparently he changed his mind. So maybe you can reason with him eventually, but like, but there's so much junk in the way. It's really hard. It takes a long time. Okay, page 7 at the bottom. The Ninth Circuit allowed California to justify its waiting period with mere rational speculation unsupported by evidence or empirical data. The court rejected petitioners' as applied challenge based solely on its, quote, common sense understanding, unquote, that the studies about cooling off periods apply to subsequent purchasers. To be sure, a law can satisfy heightened scrutiny based on a long history, a substantial consensus, and simple common sense, but not one of those bases was present here. The district court found that waiting periods do not have a long historical pedigree. It found no consensus among states that waiting periods are needed, and no consensus among experts that they deter gun violence. I got to take a drink of water. So, wow, amazing. And even assuming the effectiveness of cooling off periods is a question of common sense instead of statistics, the Ninth Circuit's reasoning was the opposite of common sense. Common sense suggests that subsequent purchasers contemplating violence or self-harm would use the gun they already own instead of taking all the steps to legally buy a new one in California. I'm going to actually read this footnote here, footnote 5. In fact, the Ninth Circuit's common sense conclusion was a logical fallacy. Studies suggesting that waiting periods decrease firearm casualties for all purchasers do not suggest that waiting periods decrease firearm casualties for subsequent purchasers. The observed decrease could be attributable solely to first-time purchasers by assuming that a conclusion about the whole applies to each of its parts. The Ninth Circuit committed the fallacy of division, See Patrick Hurley, A Concise Introduction to Logic, pages 170 to 172, 9th edition. Sorry, 6th edition, 1997. Why am I smiling? Because that is the edition, that Patrick Hurley's Concise Introduction to Logic is the textbook I use to teach logic for almost 15 years in California. That's why I'm smiling. And there's a lot of competition for that textbook because I don't know if you know, maybe you don't, you probably don't, but if you're a professor, publishers seek you out and inundate you with textbooks. They send them to you for free. I mean, I was getting textbooks sometimes once a week in the mailbox. And so, you have 20 textbooks to choose from. You choose Patrick Hurley. I chose Patrick Hurley for most of the time. I did use a couple of different ones over the years, but Patrick Hurley was the one I used the most often. So go Thomas. The Ninth Circuit's only response, so that was footnote 5. That's the end of footnote 5 on page 8. The Ninth Circuit's only response to this point was that a subsequent purchaser might want a larger capacity weapon that will do more damage when fired into a crowd, unquote. But California presented no evidence to substantiate this concern. According to the district court, California's expert identified one anecdotal example of a subsequent purchaser who committed an act of gun violence, but then conceded that a waiting period would have done nothing to deter that individual. And the Ninth Circuit did not even address the district court's finding that individuals who satisfy the requirement for concealed carry license are uniquely unlikely to engage in such behavior. Now, how do we know that? Maybe because they carry a firearm every day and they don't do that. Maybe. Needless to say, a state that offers, quote, no evidence or anecdotes in support of a restriction, unquote, should not prevail under intermediate scrutiny. That's U.S. Supreme Court precedent. Page 9. Even if California had presented more than speculation or conjecture to substantiate its concern about high-capacity weapons, the Ninth Circuit did not explain why the 10-day waiting period is sufficiently tailored to this goal. And there are many reasons to doubt that it is. California's waiting period is not limited to high-capacity weapons. Ooh, good point. Very good point. Gosh, that's a great point. Okay. The district court, yeah, I mean, it applies to like hunting rifles, right? Which are not uniquely suitable to self-harm, right? Because they're so big, they're so long. And they're not really suitable for the kind of dangers they're mentioning, right? That's good. That's good. And including long shotguns too. If you know, like these shotguns that are for hunting, they're really long. You still have to wait 10 days for that, even if you have a handgun or like an AR-15 or something, like that kind of a style of rifle. I just love that Thomas he's got such a great attention span. So he's noticing these things. He's like, yeah, well, if you're worried about like mass shootings, then how come the policy is if you have an AR-15 already in California at this time, that you still have to wait 10 days to get a shotgun, which is uniquely unsuited for like self-harm, God forbid, or, some kind of weird crime thing that you have in mind, your fantasy. It's just, I love this. I love this. The district court also found that California presented no evidence supporting a 10-day waiting period. For much of its history, California waiting period was shorter and applied only to handguns. The district court found that a 1-day waiting period is inevitable for most purchasers because their background checks are not auto-approved. Wow. You know, I'm going to go back and read this. There are many reasons to doubt that the 10-day waiting period is sufficiently tailored to this goal. California's waiting period is not limited to high-capacity weapons. Wow. Okay, that's page 9. We're done. At the bottom, page 9. The Ninth Circuit did not address the Ninth Circuit did not address these obvious mismatches between the ends and means of California's waiting period. It instead dismissed any tailoring concerns by observing that intermediate scrutiny requires only that the regulation promote a substantial government interest that would be achieved less effectively absent the regulation. But that observation was incomplete. Intermediate scrutiny also requires that a law not burden substantially more than is necessary to further the government's interest. The Ninth Circuit did not ask this second question, a question that is, of course, irrelevant to a court applying rational basis review. Lastly, the Ninth Circuit ignored several ordinary principles of appellate review. While rational basis scrutiny is not subject to courtroom fact-finding, intermediate scrutiny is. And here, the district court presided over a 3-day trial and made several findings of fact. We were in the middle of these findings of fact in the last 3 episodes of the Republican Professor podcast. I'm going to take a drink of water. The Ninth Circuit was supposed to review those findings for clear error, yet the Ninth Circuit barely mentioned them, and it never explained why it had the definite and firm conviction that they were wrong. California contends that the district court did not make the kind of historical or adjudicative findings that warrant deference. But the federal rules do not exclude certain categories of factual findings from the obligation of a court of appeals to accept a district court's findings unless clearly erroneous. Let me mention something again about the marriage decision in Perry versus Schwarzenegger, just by comparison. If you read that opinion, it's like 120 pages. Maybe I should do an episode. I should do some episodes on that. There was a clear fallacy in the district court findings of fact in the marriage decision, the defining marriage, redefining marriage. There was a finding of fact that just simply assumed marriage was different than the dictionary. So it begged the question. The whole question is, what is the definition of marriage? That was the whole question. And the finding of fact was just simply assuming that it was not what the dictionary said. Well, the Ninth Circuit was more than happy to defer to those findings of fact when they upheld the redefinition of marriage by the district court. And again, redefining marriage is not a clearly enumerated right in the Constitution, unlike owning a gun is. bearing arms, keeping and bearing arms. Just interesting. I'm just pointing it out to you. I got an idea for a future episodes. Maybe we'll do that. A court of appeals must defer to a district court's factual findings, even when the findings do not rest on credibility determinations, but are based instead on physical or documentary evidence, page 11. In fact, deference is particularly appropriate when the issues require familiarity with the principles not usually contained in the general storehouse of knowledge and experience. And no broader review is authorized here simply because this is a constitutional case or because the factual findings at issue may determine the outcome of the case. The Ninth Circuit's deviation from ordinary principles of law is unfortunate, though not surprising. Its dismissive treatment of petitioner's challenge is emblematic of a larger trend. As I have previously explained, the lower courts are resisting this court's decisions in Heller and McDonald and are failing to protect the Second Amendment to the same extent that they protect other constitutional rights. This double standard is apparent from other cases where the Ninth Circuit applies heightened scrutiny. The Ninth Circuit invalidated an Arizona law, for example, partly because it delayed women seeking an abortion. There's another unenumerated right. Redefining marriage is not an enumerated right, neither is having an abortion. The court found it important there, but not here, that the state presented no evidence whatsoever that the law furthers its interest and no evidence that its alleged danger exists or ever has ever occurred. Similarly, the Ninth Circuit struck down a county's 5-day waiting period for nude dancing licenses because it unreasonably prevented the dancer from exercising First Amendment rights while an application was pending. The Ninth Circuit found it dispositive there, but not here, that the county failed to demonstrate a need for the 5-day delay period. In other words, Ninth Circuit, huge fan of nude dancing. 5-day waiting period for a permit to nude dance? No. Is nude dancing enumerated in the Constitution? No. By the way, why is it a First Amendment right to nude dance? Because I think you're talking about engaging in a business, right? Isn't that a more like a liberty of contract thing? Like we talked about back in January? Remember? We had Justice Rufus Peckham on and his opinion for the court in Lochner versus New York. You recall that? That was about liberty of contract. Well, in another case, the Ninth Circuit held that laws embracing traditional marriage failed heightened scrutiny because the states presented, quote, no evidence, unquote, other than speculation and conclusory assertions, unquote, to support them. While those laws reflected the wisdom of thousands of years of human history in every society known to have populated the planet, they faced a much tougher time in the Ninth Circuit than California's new and unusual waiting period for firearms. In the Ninth Circuit, it seems, rights that have no basis in the Constitution receive greater protection than the Second Amendment, which is enumerated in our text. Our continued refusal to hear Second Amendment cases only enables this kind of defiance. We have not heard argument in a Second Amendment case for nearly 8 years. There's Peruta. That's worth reading. Oh my goodness. Thomas dissenting from denial of cert. We have not clarified the standard for assessing Second Amendment claims for almost 10. This is back in 2018. Meanwhile, in this term alone, we have granted review in at least 5 cases involving the First Amendment and 4 involving the Fourth Amendment, even though our jurisprudence is much more developed for those rights. If this case involved one of the court's more favored, page 13, rights, I sincerely doubt we would have denied certiorari. I suspect that 4 members of this court would vote to review a 10-day waiting period for abortions, notwithstanding a state's purported interest in creating a cooling off period. I also suspect that 4 members of this court would vote to review a 10-day waiting period on the publication of racist speech, notwithstanding a state's purported interest in giving the speaker time to calm down. Lots of case law he's citing there. Similarly, 4 members of this court, sorry, I was reading some of the comments he's making about the case law, and he quotes the N-word, which is used in one of the cases involving the KKK. And so what he's saying is, the court is more favorable to the Klan than ordinary Americans buying firearms. Sad. Gee, I wonder how Thomas thinks, what Thomas thinks about that, as the only Black member of the Supreme Court who was raised in the segregated South. I've read his book, My Grandfather's Son. It's fantastic. I highly recommend you get that book. My Grandfather's Son. It's very moving. By Clarence Thomas. We're almost done. Page 13 at the bottom. Similarly, 4 members of this court would vote to review a 10-minute delay of a traffic stop. Wow. The court would take these cases because abortion, speech, and the Fourth Amendment are 3 of its favored rights. The right to keep and bear arms is apparently this court's constitutional orphan, and the lower courts seem to have gotten the message. Nearly 8 years ago, this court declared that the Second Amendment is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. That's from McDonald, 780. By refusing to review decisions like the one below, we undermine that declaration. Because I still believe that the Second Amendment cannot be singled out for special and specially unfavorable treatment, I respectfully dissent from the denial of certiorari. Thomas J. dissenting. Okay, that's it. So we'll continue with Ishii getting through the 10-day waiting period, and we'll move on to other topics. We have a special interest here in the Second Amendment. I have some ideas for Fourth Amendment stuff I'd like to talk about. Government power is a topic here. And we also have other interests here as well. I mean, I don't know if you know, but we're in the middle of Helmut Thielicke as well on theological foundations. So we got a lot going on here. And thanks for joining us on the Republican Professor podcast.